State of Ohio v. Terrian, Wray. Ms. DiMartino will be representing the appellee. Mr.
Patituce, Your Honor, yes.
Patituce will be representing the appellant, Terrian Wray. You will each have up to 15 minutes to present your arguments. Mr. Patituce, you will be able to reserve 5 minutes for rebuttal should you so desire. And if you do plan to reserve that time, please let me know, as I'll be keeping track of the time. The arguments are being recorded, so please stay behind the podium and keep your voices up. You should not use the names of children or minors or victims during your argument, and you refer to them by initials or general terms. We have read your briefs, and we are ready to proceed when you are. Would you like to reserve some time?
Yes, Your Honor. On behalf of Mr. Wray, I'd like to reserve, if necessary, 5 minutes. Your Honors, may it please the Court, we presented to you 4 assignments of error, and I know that in appellate practice, often sufficiency and manifest weight are attached as what some people will call throwaway, or let's just raise it so we don't waive it. But I think here there are assignments of error that we need to take a long, hard look at. And in our sufficiency argument on behalf of Mr. Wray, we really have essentially 2 components that we're talking about. The first is the identity issue. Was sufficient evidence presented that Mr. Wray even committed the acts that he's accused of? And then the second component of it is, if this court believes sufficient evidence existed for that, was there sufficient evidence to establish the premeditation aspect of aggravated murder? First, as it relates to identification, I think our courts are instructive here. There's really 3. Well, first, for identification, what is the evidence that connected Mr. Wray to this crime? He was involved in a brief argument with the deceased, and that is essentially where it ends. There is a witness with the last name Taylor who says, I was 70% or 80% sure it was him. However, ironically, as it relates to Ms. Taylor, and something that we need to take into consideration, it was her DNA that was found on the shell casings that were left at the scene. There was no DNA, and this is an oddity. The DNA here was an exclusion for Mr. Wray. He was not connected to the casings. He was not connected to the mask or hat that was allegedly worn by the perpetrator. Now, Mr. Elkins, his DNA showed up on the hat that matched the description of the shooter that was found in the backyard from where this shooting occurred. There were witnesses who testified that they saw Mr. Wray walking down the street, and I apologize, I forget the direction he walked, because there's a vehicle, an orange SUV, that appears on scene, which is where the shooter allegedly comes from. And I don't recall, and I don't want to mislead the court, as to which direction, which party was coming from. Essentially, they were coming from opposite directions. Mr. Wray was walking away, the SUV was coming on scene, and the camera and the video evidence that we have, if all the evidence is believed, Mr. Wray was away from where the shooting happened when the shooting occurred. So to me, it's a stretch to say that the state proved beyond a reasonable doubt that Mr. Wray was the gunman. And let's not forget, this was the second time this case was taken to trial. The first case ended with the jury unable to reach a verdict. And obviously we have no knowledge of what the vote was. We have no way of looking back to say what the issue was in the first trial. But there was really no difference between the evidence. The evidence presented was the same, which then ties us, I believe, into our assignments of error number 1 and number 4. What changed here? And in my career, this is the first time that I've seen this happen, where a courtroom deputy was so concerned with what he was observing, between communication from the gallery and communication to the jury box, that he brought it to the court's attention. I've never even heard of that happening. And here we have the courtroom deputy testified that he, and this wasn't the first time this particular juror had an issue, but he observed that when the parties were at sidebar, that the victim's family was communicating, it appeared by text, that they would take out their phone, there would be a text message sent to somebody, and that the juror appeared to be communicating back and forth. And that's his testimony. I think it's in the 1420 in the transcript, where the courtroom deputy is testifying that it appeared that there was communication, there was non-verbal communication, laughter back and forth. It appeared for all intents and purposes that there was communication. All the parties agreed, including the court, that this juror should be removed, but then he wasn't removed, or she wasn't removed. The record doesn't really make it clear as to who this particular juror was, but the juror was allowed to retire with the jury after the after the parties had rested, stayed in the jury room for an indeterminate amount of time, came back the next day where they were there present again, and no one followed up on, which I think are the two most important things that should have happened here, was one, a voir dire of the panel. Let's find out, was the panel infected? Was this spread throughout the panel? Because clearly, whether it's the defense, the public, or the victim's family, nobody should be communicating with the jury in any case, let alone an aggravated murder. And then, even though everybody had agreed that the juror should be removed, he wasn't removed. And I do understand he was an alternate, but he was still on the panel. He was still traveling with and going to and from with the jury. This wasn't the first time that the court mentioned that they had an issue with this juror in communication, that it appears that in the hallway this juror had reached out to talk to other people. And this seems like again, and I started with, I've never seen this before, so I don't fault the court or counsel too much, but there was an error here, and we should have at least went to the next step of, was there communication? And I know the state's case or the state's argument is, well, Mr. Patitucci, you can't prove prejudice. The first question is, does the defense need to prove prejudice when we have communication from the victim's family to the jury? Does prejudice need to be proven, or is it assumed? And I think that when we look at the line of cases that come out of both the United States Supreme Court and our own courts, that prejudice is assumed. That when you have communication from an outside party with the jury, that prejudice is presumed. And that if it's the defendant that's doing it, the state is entitled to ask for a mistrial. If it's the victim's family, I think the defense should have asked.
And that's your argument that goes to your ineffective. They did not ask for, counsel did not ask for mistrial.
Counsel did not ask for a mistrial. Did
counsel ask in the record for any kind of curative instruction, for any kind of voir dire of the witnesses, or make any request to the court on how we're to deal with this?
No, Your Honor, and that is where again, I had not encountered it, but if I had been a trial attorney, this very first thing I would have asked for was a mistrial. And if the mistrial was not granted, I would have asked for a voir dire of the panel, and it would have been interchangeable. In the Tug of Violence murder trial that I conducted in Cuyahoga, we had a situation where the jury obtained something that they shouldn't have obtained, and what that judge did was they conducted a voir dire of the panel. It took 5 minutes, and within the 5-minute voir dire, it was determined that 3 of those jurors had relied upon it. Just by anecdotal, this is possible, it's something that can be done, and the judge found that we had to start the trial over again. And I think that is something that the defense attorney could have asked for here, and it's a very easy thing to ask for. Let's just ask the jurors, have you talked to this other juror? Is there anything that's influenced you, or has anything been discussed? And if the answer is no, then I don't know that I have a whole lot to talk about as it relates to this issue, but here there was no steps taken in order to protect Mr. Wray's right. And again, this was the second time this case was tried. It was hung the first time, and now the second time the difference appears to be communication. Maybe that's sympathy. I mean, we're talking about a murder. Someone really is truly dead. That's an emotional, moving thing, and we can't, I'm not underselling that. I'm not saying, or trying to belittle that at all, but when this high of a stake, and what's at risk is so high, I think everybody should have slowed down and taken a moment just to voir dire, at least ask, or the defense be assertive, assert the Sixth Amendment, ask for a mistrial, ask to start again. I know that would have been an inconvenience, but Mr. Wray, at the end of this, essentially got a life sentence. He's in prison for the rest of his life.
The record seemed to indicate, though, that the parties were satisfied with the plan of just not having the alternate sit. At that point in time, skipping over the alternate, someone had to leave. The record seemed to indicate that everyone was, no one objected that when it was discussed, here's the plan. No one said, I'm not comfortable with that. Is that fair?
My reading is close to that, Your Honor. My reading was, essentially, we're going to deal with it tomorrow.
Okay.
We'll come back tomorrow and we'll remove him because we've already had so many problems with this juror, all the way up from the inception in jury selection to, I think he wasn't answering questions. If you read the voir dire surrounding him, he wasn't asking questions correctly. He was a lot of oddities about his ability to get the truth from looking at people, things like that, and then conduct during the trial, and then at the end, I think it was the end of the day. The defense attorney had Facebook exhibits that he wanted to make part of the record that he had forgotten, so he was going to bring those back. And the guy don't follow him, it was 5 o'clock at night. He was going to the next day. And I think my understanding of it, at least the court's term plan, was to just address it in the morning.
So, throughout this, does the record reflect that the jurors received the standard admonitions about not discussing the case amongst themselves and pre-deciding the case and things of that nature before it was submitted to them? Are those advisements in the record?
I don't know, again, I don't want to mislead the court and give an answer where I don't know the answer to. I do know in the beginning of the court, the proceedings, they were told if somebody approaches you, an attorney, somebody on the street approaches you, you're supposed to report it. They did receive those admonitions. My memory, I don't recall if at the end of the trial if they had any additional admonitions, and I don't want to mislead you, Your Honor.
Well, in that, the state's reading of the record, and I'm sure we're going to hear it, but it seems to be from the brief that there were no deliberations with this particular juror present, and that the record is clear that that's the case. That's why I'm asking if there were admonitions made with respect to all those things that jury is always told about not talking about the case amongst themselves, so on and so forth, between themselves.
I understand what you're asking, Your Honor, and I do not think the record is clear as to what happened in that room. Essentially, it sounds as if they were just sent to the room to sit and wait while the attorneys in the court work through matters. But as far as admonitions go, this juror clearly, and I think the state would agree, this juror was clearly throwing those admonitions by the side. He was communicating with the victim's family. He was interacting with them, and that's an admonition that they were given in the beginning. Now, as far as the admonition goes...
Counsel, I do want to let you know that you're in your rebuttal time now, so you're about at 4 minutes.
I will just conclude with, as far as the admonition goes, Your Honor, and I think it's a great question, is that this jurors are typically told, don't communicate with outside individuals, which this juror clearly disregarded. But I don't think that admonition in that exact line, that direct line says don't communicate with each other. Now, there is so I think that's something that, as you're asking the question, popped into my mind, is they're told every day, you might see Mr. Patatus or whoever the attorney is, they're not being rude, don't talk to them. If they do talk to you, tell us. But I don't think they're told, hey, if your other jurors talk to you, you can't talk to them. So I think that's where I would draw the distinction there. And I know I'm into my rebuttals. Thank you.
Thank you. You'll have a little over 3 minutes from the counsel.
May it please the court, Heaven DiMartino on behalf of the state of Ohio, the appellee, we are asking that this court affirm Mr. Wray's convictions leading to the death of DR as well as the felonious assault of DT. I'll start with the issues with the first alternative juror. With regard to the statements by opposing counsel, the record shows that this conversation with the deputy and the court and the prosecutor occurred on page 1295 and ended on page 1298 of the transcript. There is no statement that says that the state agreed that there was a conversation between this alternative juror and the victim's family. There's no finding by the court that is what occurred. What the record shows is that the deputy said when they first came in, this alternate juror was looking at the gallery. He pulled out his phone and sent a text and, quote, I assume it was the victim's family came in and he was looking. He nodded his head when they came in. They asked him about it additionally, and he says, I can't say for sure. The court says, I don't know that he would have been texting them, but he shouldn't have had his phone out at all. So there is no agreement or belief, nothing in the record more than an assumption and timing that looked suspect. The court indicated that there had been prior issues with the juror, none of which, according to the record, arose to the level that anyone asked to have this juror excused before. So anything that may or may not have happened earlier has nothing to do with the issue of whether this juror had a conversation with the victim's family, which is the argument that that would have been something that could have possibly caused reversible error. The state is saying that there's no evidence that that happened. And to keep talking about the fact that at one point this person looked at people, so the court had a conversation, and the court indicates this alternate juror said he's an observer of the people, and that's why he kept looking at people. He then came in with sunglasses. His oddities, as opposing counsel put it, are not dispositive of the issue here, which is if there had been evidence in the record that there was actually a communication with that alternate juror, that would be a different record. This record does not support that. The court actually says, I would rather not excuse him on page 1297. I believe it will embarrass him, not that that's what matters. I believe this case is going to get to the jury at lunchtime. We will not have to activate an alternate juror. We can excuse him with the others. The state does not agree, and the court does not agree to excuse the juror. Instead, the prosecutor says that they would address the matter in the morning if necessary. He acknowledges that there were 3 issues, so there are concerns, but at this point, he's not on the jury. I don't see why we can't just address it in the morning. When they return in the morning, the court says, I don't believe the state has officially rested. We're going to proceed with that. The state rests. There's conversation about some evidence that the defense would have to put in the record. They do general jury instructions and closing arguments, and then the alternate jurors are excused. So there's absolutely nothing in this record to show that there was in fact a communication, just some timing issue with the text, some nodding at the family, and then there's no evidence in the record that this alternate juror had any deliberations with the jury. What it does show is that once the alternates were excused, the court tells the jury not to begin finding the 4-person and deliberating until the alternates have left the room. So with nothing in the record, there's no basis for this court to find that the trial court inappropriately handled the issue or that trial counsel was ineffective, because those things are just not in the record. With regard to the assignments of error for the sufficiency and weight of the evidence, the record in this case shows that all of these individuals were together for multiple times over a couple of an hour period. And in this case, the decedent and another individual, J.E., they were like brothers, they were friends. J.E. was having some issues at his place, so the decedent and J.E. went over to the decedent's place, basically bringing some clothing back and forth. At one point, Mr. Wray was with them. Mr. Wray at one point leaves and gets into a red SUV, which you see through the transcript keeps coming up, this red SUV. To make a very long story short, at some point, Mr. Wray goes back to J.E.'s house looking for them. They're not there because they're back at J.E.'s house. When D.R. and J.E. return to J.E.'s house, J.E. goes inside, leaving D.R. outside a locked door, where 9 shots are fired, 7 strike the decedent, who is banging on the door, asking to be let into the house. A neighbor, Ms. Carswell, sees the shooter, recognizes Mr. Wray from earlier, where he was wearing all black. He was again wearing all black. She identifies him. She identifies him as being there earlier. She identifies him in a photo array. DT, who is J.E.'s girlfriend, she also said that the shooter was wearing all black, just like Mr. Wray was. And then another neighbor who's walking her dog saw a man all in black with a gun get into that same red SUV that we've heard so much about through the transcript. So there is sufficient evidence that the shooter in this case was Mr. Wray. It's evidence that there was prior calculation and design because he hunted down DR. He waited for him to be outside. He fired the gun 9 times at him. The witness saw him empty the clip, reinsert it. The decedent was struck 7 times. That is sufficient for prior calculation and design as well as for purposeful murder. If there are no questions, I'll rest on my feet. Thank you, Your Honor.
Hearing none, thank you. And counsel, you will have 3 minutes and 16 seconds for your rebuttal.
I only need 3 minutes and 14 seconds.
Okay.
First, Your Honor, going through the state's arguments, if we look at the transcript page 1297, the state of Ohio agreed that he should be excluded after the hearing and after the testimony. That's at 1297 in the transcript. The state of Ohio straight up says this juror should be removed from the panel, and that was the evening before they left. This trial court made a finding, I believe, and I'm quoting here, I feel like there's sufficient reason at this point to, in all due caution, to excuse this juror. The trial court made a finding that this juror should be removed.
Counsel, you mentioned that the juror was deliberating for an indeterminate amount of time or something to that effect. Can you just explain a little bit more about that situation? Because obviously the state argues that the juror was not engaged in any deliberations and was excused.
Sure, Your Honor. If we look at the transcript, it's transcript page 1422 through 1425. Despite the state's contention here, and I had to go back and double check, but our contention is that they were sent to the deliberation room without the advisement to go back and pick a foreperson and don't deliberate until the jurors have left. The state rested, the case is over, and they're sent into the jury room. There is no record of what happens after that. There's no record of how the alternate was removed. Normally, and in my experience, and my experience doesn't mean much, but normally the alternates they don't go back into the jury room. They leave, or their belongings are brought out to them. They don't go into the jury room because they're not going to be on the panel. I know every county does it differently, and my experience in Summit County has been that their belongings are brought out to them, and then they leave and they're put on call if needed. They're told not to talk to anybody, don't tell anyone how you voted. We don't have that here. So
I'm sorry, you say we don't have that here. We don't have that in the record, that that's how it transpired, or that we have something in the record that says that it transpired in a different way?
No, we have not. The record is devoid of how, and I know that in general, if the record is silent, we assume regularity, but here, I think there's enough in the record to show irregularity, in that this wasn't a simple passing glance, or the juror didn't just glance over at the victim's family. It was so pervasive that a courtroom deputy had to bring it to, and had the integrity to bring it to the trial court's attention to say that this is an issue. And immediately following his testimony, the trial court found, I feel that there's sufficient reason at this point to excuse him. That was a finding that the court made, except the person stated it could have been excused that night, right there. Could have been removed. And then we could have went into the other items that we talked about, voir dire the panel, talking to see if this person had discussed it with anybody. And then at the end, after the state formally arrests on the record, at the 1422 to 1425, they're sent into the jury room with no further instructions as it relates to the alternate. So, and that is an instruction that is typically given. Do not deliberate until you proceeded to pick a foreperson. And that we don't, that's not there at this point. So based upon that, I do respectfully disagree with counsel. There was no instruction to go back and not deliberate until the foreperson is picked.
And counsel, I'm going to need for you to wrap up.
I am finished, Your Honor. Thank you.
Thank you so very, very much, both of you, for your presentations. The court will take the matter under advisement and issue a decision in due course. The clerk of court will mail a copy of the decision to you on the day that